Good afternoon, everyone, and thank you for joining us for this one-hour webinar on employee conduct out of hours. My name's Fiona Kenny, and I am your moderator for today. This webinar is brought to you by Australian Business Lawyers and Advisors, who just last week won Workplace Relations and Employment Team of the Year, so you are in excellent hands. Today, I'm joined by Jeremy Kennedy and David Cameron from the firm. Before I hand over to them, if you have any questions during the webinar, please submit these via the chat box on the bottom left-hand side of your screen. You'll see a small grey cog icon where you can enter your messages to the right of it in the grey box. We will endeavour to answer as many questions as possible throughout the presentation, and if we run out of time, we'll respond to you privately. Just a note, this is a private chat, so you will only see the questions and answers that you submit. I'll now hand over to David and Jeremy.
Hello everyone, hopefully you can hear us now. We're about to start the webinar. Misconduct outside of the workplace can have adverse effects for workers and employers alike. Misconduct can take many forms, and it is often difficult to know precisely where the workplace ends and private life begins. As with a great many things, prevention is better than cure, so it is important for workers and employers to first know their respective rights and responsibilities, and second, how to address issues if they nonetheless arise. The Fair Work Act is the most prominent legislative instrument relating to workplace law. The Act is important because it sets out many of the rights and responsibilities of employers and workers for the vast majority of Australia. Many of those rights and responsibilities intersect with misconduct in some way. For example, an employer's duty to provide a safe workplace can be impeded where discrimination or bullying is observed. The Act also describes adverse action and unfair dismissal, which are two areas of recourse that workers may rely on following disciplinary and other action taken by an employer in the aftermath of misconduct. The Act and the ones it replaced do not, however, legislate about misconduct outside the workplace specifically. The Act is therefore supplemented by common law from many Australian jurisdictions over the course of decades. We intend to give summaries of some relevant cases, but please note, listeners, that they are neither intended to be a fulsome review nor a substantive delineation of all the facts, so you should seek legal advice if any of the circumstances described hereafter bear a resemblance to those confronting you or your organisation. To begin with, both parties to an employment contract or covered by an enterprise agreement should know that neither party has an absolute discretion in relation to a worker's behaviour outside of the workplace. Where a reasonable and enforceable contract, agreement or policy provision exists, employers are able to control some aspects of a worker's life outside of the workplace. Even in the absence of such a provision, some extreme forms of misconduct will permit a fair dismissal. For example, it would be unusual for an employment contract to specifically forbid a worker from assaulting colleagues, but the absence of such a provision would not ordinarily preclude a fair dismissal of a worker who has assaulted another. Two early cases to deal with misconduct outside the workplace were Hospital Employees Federation of Australia and Western Hospital, and Hussain and the Westpac Banking Corporation. In the former case, Deputy President Lawrence said, quote, "The conviction of an individual for a criminal offence does not necessarily have any effect upon that person's employment. The question of the relevance of a conviction or an employee's alleged misbehaviour to the employee's work should be considered in terms of whether or not the employee has breached an express or implied term of his or her contract of employment. Whether events occurring outside the actual performance of work will be relevant to the employment relationship will vary from case to case. For example, an accountant who has committed an act of dishonesty for which he or she may have been charged and convicted, in the course of some activity outside his employment, might be said to have breached a term of his contract of employment." End quote. In the latter case, a similar event happened as DP Lawrence foreshadowed. A banker pleaded guilty to a charge of obtaining property by deception. The banker had purchased an unregistered firearm via allegedly fraudulent use of a credit card sourced from a different bank to his employer. His employer considered that behaviour to be incompatible with his job and terminated his employment. In both cases, DP Lawrence and Judicial Registrar Staindl respectively considered whether the misconduct had a relevant connection to the employment and in effect constituted a breach of the employment contract. Judicial Registrar Staindl explained the concept of the relevant connection thus, quote, "In my view, a conviction on a drink driving charge which occurred outside work hours would not be relevant to the employment of many people. However, it would be of critical relevance to a truck or a taxi driver. It seems to me that an appropriate test is whether or not the conduct has a relevant connection to the employment." End quote.
David, can I just make a comment there in relation to those cases that you're talking about? They have looked at the issue of breach of contract. I think there's another very important point that we can make in relation to employees' conduct outside of the workplace, particularly when it comes to criminal offences, which are similar to those cases that you've been talking about, and that is that if they are sentenced to a custodial sentence by the court, or if there are orders made by the sentencing judicial officer that a person attend, for instance, some form of rehabilitation if it's a drug offence, for instance, that will then frustrate the contract of employment. So we're not looking at a breach of contract, we're actually looking at frustration of contract, which gives employers another option in terms of termination.
Quite so. The case law has developed incrementally since the time we was discussing. In 1998, a significant case came before the Australian Industrial Relations Commission. In Rose and Telstra Corp, two Telstra workers were travelling to country towns on maintenance duty. After work one day, the two workers went to dinner and then a nightclub. They were neither on call nor in uniform, but it was generally known in the town for whom they worked. Numerous alcoholic drinks were consumed by both workers. Later, at the hotel where they were staying, an argument developed into a fistfight. One worker broke a window and stabbed the other with a shard of glass, requiring several stitches. The worker who stabbed the other was taken into police custody and charged. He was convicted and resigned his employment. The worker who was stabbed was dismissed by his employer, who considered him to have conducted himself improperly. The worker lodged an unfair dismissal application and, as he was at the time Vice President, now President Ross, found his termination was harsh. The important lesson found in that case was summarised by His Honour when he said, quote, "It is clear that in certain circumstances an employee's employment may be validly terminated because of out-of-hours conduct, but such circumstances are limited. 1. The conduct must be such that, viewed objectively, it is likely to cause serious damage to the relationship between the employer and the employee, or 2. The conduct damages the employer's interests, or 3. The conduct is incompatible with the employee's duty as an employee. In essence, the conduct complained of must be of such gravity or importance as to indicate a rejection or repudiation of the employment contract by the employee." End quote. In the same case, His Honour confirmed, "Employers do not have an unfettered right to sit in judgment on the out-of-work behaviour of their employees. An employee is entitled to a private life." Hundreds of times since the Rose decision has a worker's private behaviour been found to be misconduct because the behaviour came within the limited circumstances VP Ross enumerated. We will approach them by topic. Topic 1. Alcohol. In Gallagher and Gold Coast City Council, an animal control inspector attended a Christmas party with her colleagues. She became drunk and argumentative. Once ejected from the party, she argued with a policeman, grabbing his tie. She was not charged, but after a write-up in the local newspaper, the worker was dismissed for that misconduct and for neglect of her duty. The worker lodged an unfair dismissal application with the Queensland Industrial Relations Commission. Commissioner Baldwin found, in making the decision to terminate the worker, the employer did not consider some of the other unresolved issues between the parties. The dismissal was determined to be unfair. An important rule from that case is that an employer who dismisses a worker for reasons other than those stated in the dismissal letter can be ordered to reinstate the worker and pay compensation for lost wages. Commissioner Baldwin also said Christmas parties were notorious for creating the impression that the usual workplace protocols and restraints are relaxed. Sure, that's certainly not a misapprehension held by our listeners, Jeremy. A recent example of a Christmas party gone awry was the case of Keenan and Leighton Boral Amy joint venture. At that party, an open bar was provided by the employer. A worker became verbally aggressive after consuming numerous drinks. After the party in an adjacent bar, the worker kissed a colleague on the mouth unexpectedly. The worker was dismissed for that misconduct, and he then lodged an unfair dismissal application. The Fair Work Commission found that although the employer had a valid reason for terminating the worker, the dismissal was disproportionate to the gravity of the misconduct. Of assistance to the worker was that he was not afforded procedural fairness in the dismissal process.
David, could I just make the point there, those cases that you're looking at now deal with unfair dismissal matters where workers have commenced action for unfair dismissal. But I'd like to make the point also that there are obligations on employers as PCBUs or person conducting business and undertakings under the work health and safety legislation. And those obligations would extend to doing everything reasonably practicable to ensure the safety of workers at work. And if you are having a work-sponsored or work-related party, then it would be incumbent upon the employer to give direction to their employees about appropriate workplace behaviour, and also, if they're going to be involved in consuming alcohol, to ensure that there's some guidance and direction given to their employees about the consumption of that alcohol, and even their obligation could extend to ensuring that those persons are able to get home safely, whether that's via carpooling or some other means. But certainly, I think there's also a work health and safety aspect to these types of matters, particularly where there is alcohol involved, the old Christmas party, and any other work-sponsored or work-involved functions.
Not every case involving misconduct outside the workplace involves aggression. In the case of Selak and Woolworths, a supermarket worker of 20 years' service drank 2 pots of full-strength beer during his lunch break in breach of a zero-tolerance alcohol policy. He was dismissed for breaching that policy, and he thereupon lodged an unfair dismissal application. At first instance, his application was dismissed because Commissioner Granger rejected the argument that the dismissal was disproportionate to the gravity of the misconduct. The worker appealed that decision to the full bench of the AIRC, but they dismissed the appeal. In both instances, it was determined that it was not unfair to dismiss the worker for having 2 beers in his lunch break because a policy existed, it was clear, and the worker was aware of the policy. Also in 2008 was the case of Wayne Edward Collins and the Commissioner of Police. A policeman was dismissed for discrediting the New South Wales Police Force for a drink driving incident in which his passenger broke a wrist. When his superiors became aware the policeman returned a .153 BAC reading, he was dismissed. Although the New South Wales Police Force took into account that the policeman was celebrating the birth of his first child, they did not consider his previously unblemished record, the impact on his young family, or that the policeman underwent counselling and repaid his debt to society. The New South Wales Industrial Relations Commission considered it a momentarily reckless error of judgment and ordered his reinstatement, but this was reversed on appeal 6 months later when the full bench giving special consideration to the public interest. In Collegasney and J. Bogue and Son Brewing Pty Ltd, a brewer was charged with drink driving and was dismissed. That worker lodged an unfair dismissal application, but the AIRC considered it a fair dismissal because the employer had a strict alcohol policy, it was clear, and the worker was aware of it. The employer's position was helped by the fact that it operated a brewery and that alcohol-related offences more acutely reflected upon it when compared with other employers. The worker appealed the decision, seeking leave on the basis that the AIRC failed to consider termination being disproportionate to the misconduct and failed to consider his otherwise good working record. The full bench said that the AIRC did adequately consider those aspects of the case, and so his appeal was dismissed. One unifying theme that our listeners may have discerned is that where a worker is likely to bring their employer into disrepute in a way which is wholly inconsistent with their job, a resultant dismissal is more likely to be considered fair. The banker who acted fraudulently, the policeman who acted contrary to the public interest, and the brewer who drank irresponsibly are all examples of workers in jobs where there could be said to be a more stringent expectation of their behaviour outside of work. But not all instances of misconduct outside of work involve intoxication from alcohol. There are some circumstances in which employers are able to reasonably and lawfully direct workers to undergo a drug test. In Caltex Australia and Australian Institute of Marine and Power Engineers, Sydney branch, a determination was made by Fair Work Australia amidst a bargaining dispute over the terms of a proposed enterprise agreement. The employer operated within a critical risk industry. The workplace was a refinery where significant amounts of flammable material was stored. The employer sought to introduce random drug testing as a way of balancing that extra risk with its duty to provide a safe workplace. The workers resisted its introduction, citing a number of concerns, especially that the policy had a disciplinary focus rather than one for counselling and rehabilitation. Fair Work Australia determined that employers can direct workers to undergo random drug tests if, for instance, safety is an issue. Addressing many of the workers' concerns, the testing must be compliant with Australia's standards and the treatment must be from a medical and safety perspective, not a disciplinary one. In Harbour City Ferries and Toms, a ferry master agreed to perform a shift unexpectedly when a colleague became unavailable. While the worker was at the helm, the ferry incurred minor damage in a collision. At the employer's direction, the worker underwent a drug test. The worker returned a positive reading for recent cannabis consumption and was dismissed. In his unfair dismissal application, the worker argued that despite the test results showing that he had consumed cannabis, there was no evidence that he was actually impaired at the time of the collision. He was reinstated because the FWC considered his dismissal harsh. On appeal, the full bench quashed the reinstatement order, determining that the worker's disobedience of the employer's well-known zero-tolerance drug policy was a valid reason for his sacking. The full bench also said, quote, "We are not persuaded that urine testing, the agreed method of drug testing at Harbour City, is a guide as to the actual presence of marijuana in an employee's system or any impairment arising as a consequence. It is a testing system which, in this case, indicated past use and no present impairment," end quote. The worker appealed the full bench's decision, but the full federal court dismissed it. In the last decade, workers have lodged unfair dismissal applications with Fair Work Australia and the Commission which superseded it, and have argued that their positive drug test results were purportedly due to passive smoking, not knowingly taking drugs, and even being held down and forcibly administered drugs by friends. All of those cases involved employers in industries where there were serious safety risks. None of those cases resulted in a finding of unfair dismissal. In one particularly egregious example of misconduct, a worker returned a positive result, was dismissed, lodged an unfair dismissal application, and handed up to the Commission falsified evidence showing a negative result. In that case, the Fair Work Commission awarded the employer their costs on an indemnity basis. Another unifying theme our listeners may have discerned from these cases about drugs is that where worker and public safety are at stake, where employers have clear policies known by the workers, and where drug testing is conducted appropriately, dismissals for misconduct outside of the workplace are more likely to be considered fair. The object of Part 3.2 of the Fair Work Act, which sets out the laws relating to unfair dismissal, notes its intention to ensure a fair go all round is accorded to both the employer and the worker concerned. It is prudent here to remind our listeners that dismissal is not the only and not always the most appropriate disciplinary tool for all instances of drug or alcohol-related misconduct, and that the Commission is likely to take a favourable view of an alcohol and drug policy's focus on counselling and rehabilitation. Topic 3. Sexual harassment. Some of our listeners might not know that sexual harassment can occur outside of the workplace. It is therefore appropriate whenever instructing workers about sexual harassment to include a warning that being outside the workplace does not relax standards of conduct required. The types of directions an employer can give to mitigate against sexual harassment have developed over the years. In the case of McManus and Scott Charlton, an employer directed a worker not to contact a colleague outside the requirements of official duties after the colleague complained of the unwelcome nature of his calls. The worker took exception to that direction and litigated. The federal court determined that it is lawful for an employer to give a direction to a worker in relation to out-of-hours sexual harassment where, 1. Harassment can reasonably be said to be a consequence of the relationship of the parties as co-workers, and 2. The harassment has and continues to have adverse effects on workplace relations. In Johnson and the Department of Justice and Attorney General, a worker lodged an unfair dismissal application after being dismissed from his employment with a Queensland Government department for allegedly sexually assaulting 2 female work colleagues. Part of the misconduct took place outside the office and working hours where the worker was intoxicated. The employer claimed that the worker's conduct breached Public Services Code of Conduct, as the behaviour amounted to both sexual harassment and a failure to treat colleagues with respect. The worker apologised for the misconduct and was said to have shown considerable contrition. Evidence showed that on each occasion the worker was grossly affected by alcohol. The Commission found that the worker's comments and conduct towards his female colleagues amounted to disrespect, but not sexual harassment. The Commissioner said that sexual harassment is not an absolute offence that justified dismissal in every case. The worker's conduct did not reflect seriously and adversely on his employer and did not justify the department's intervention. The worker's application was granted and his dismissal was declared unfair.
David, could I again make a comment in relation to those cases that you're talking about? You're looking at those cases from the aspect of justifying termination. I think it's also important to consider the vicarious liability that employers have for the conduct of their employees from a discrimination and equal opportunity legislation point of view, where they can be found to be liable if they don't take reasonable steps under that legislation. And I think In those case examples that you've given, particularly the last one where the worker was successful, the employer did the right thing under the EEO legislation in taking steps against that particular employee. So I think there's two elements to it. There's the justification for the unfair dismissal, but you also need to consider the obligations that an employer has and how they can be vicariously liable for the actions of the perpetrators.
It is indeed a fine line to tread. In Telstra and Streeter, a case attracting a good deal of publicity at the time, a worker was dismissed for sexually harassing colleagues. A group of colleagues paid for a hotel room so they could sleep there following a work party. The worker in question engaged in consensual sex with two colleagues in that room and in an adjacent bathroom, in close proximity to the other colleagues attempting to sleep. The colleagues inevitably became aware of the sex acts. The employer conducted investigation into what happened during the night after receiving complaints from some of those colleagues. The worker in question alternately refused to answer some questions while asserting memory loss for others. Her employment was terminated once the employer was satisfied that the colleagues had been sexually harassed. That worker lodged an unfair dismissal application and, at first instance, the AIRC said her behaviour was not sexual harassment and she was reinstated. Her employer successfully appealed that decision, which overturned the reinstatement because of the worker's dishonesty during the investigation process. We expect that having a clear policy in place is likely to be helpful, but employers should always perform their investigations in a timely and measured way, taking into account both sides of the story before forming a view, and that even when an employer determines a worker to have conducted him or herself in contravention of a policy, dismissal is not always appropriate. Note also that some forms of sexual misconduct will go beyond employment law and into the realm of criminal law. Topic 4. Social media. From about 2010 onwards, there have been a great number of social media cases. In one of those cases, Fitzgerald and Escape Hair Design, a disgruntled hairdresser used Facebook to post messages about her employer and the hairdressing industry. With a combination of words and pictures, she said she would receive no Christmas bonus that year and, with false enthusiasm, cheered the hairdressing industry at large. Her employer dismissed her as a result of those posts. Following her termination, she lodged an unfair dismissal application with Fair Work Australia, which held that out-of-work conduct such as posting critical comments about an employer on a website such as Facebook may affect the employment relationship of trust and confidence. The worker argued that her employer could not be identified and was only accessible to her Facebook friends, although this included some clients of her employer's salon. Fair Work Australia found the dismissal was unfair because while the comments made were imprudent, they did not provide a valid reason for dismissal. The comments were not detrimental to the business, and the employer had not raised the comments with the worker at the time they were made. Furthermore, dismissal occurred more than 4 weeks after the comments were posted, which demonstrated that the significance of the posts, as perceived by the employer, was overstated. A year later, another worker was not so lucky. In Damien O'Keefe and William Muir's Pty Ltd, trading as Troy Williams, the good guys, a retail worker was agitated by his employer's repeated failure to pay his wages correctly. He responded to this by posting to Facebook a number of comments about his employer's perceived shortcomings, and, amid some colourful language, he said that they were going down tomorrow. Inevitably, his employer became aware of the aggressive comments and chose to terminate the worker's employment. The worker lodged an unfair dismissal application, arguing that the comments were made privately via his personal computer outside of work hours. Deputy President Swan upheld the dismissal, noting that although the comments were made privately, his arguments about using his home computer computer outside of work hours did not make any difference to the fact that his conduct warranted dismissal. Topic 5. Workers' compensation. One particularly well-known workers' compensation case involved not so much misconduct as a form of conduct not ordinarily found in the workplace. The case was Comcare and PVYW. In that case, a worker was travelling to and overseeing different regional work sites, staying in motels paid for by her employer along the way. On one such stay, the worker was engaged in sexual congress when a glass light fitting on a nearby wall fell and impacted her face. She required a trip to hospital for her nose and mouth. When denied the workers' compensation she sought, the worker appealed to the AAT, the Federal Court and the full Federal Court, arguing that the injury was sustained in the course of employment. A majority of the High Court held that in order for an injury sustained in an interval or interlude during an overall period of work to be in the course of employment, the circumstances in which the worker was injured must be connected to an inducement or encouragement by the employer. The court said that if the worker was injured whilst engaged in an activity at a certain place, that connection does not exist merely because of an inducement or encouragement to be at that place. The majority held that the activity engaged in by the worker in this case, when she suffered injury, was not connected to or induced by her employer.
David, whilst we all enjoy those salacious facts, there are quite a number of other cases that look at whether workers have been injured in the course of their employment, particularly cases where workers are required to travel. There's a number of cases that I'm aware of. Kennedy versus Telstra. The facts in that case were a worker was required to work away from home. And again, it involved alcohol to an extent where he had gone out with workmates or colleagues that evening. They'd been to a local hotel. On the way back to their motel, they were accosted by a group of Aboriginal people who were intoxicated, who then followed them back to their motel car park, and there they were all assaulted. In that case, I think the full bench of the Federal Court found that that worker had been injured in the course of his employment, despite the fact that he'd been out for dinner, and I think they'd had a punt on the TAB and various other activities before they got back to their motel room. There's also, I think, a case of Lewis and Inverell Shire Council, which is where a worker was required to work away from home, stayed in a caravan park and decided that he would stay for the weekend instead of travelling back home, and attended a barbecue or a party in another caravan on the Saturday night. And there was a fire in that caravan whilst the party occurred, and he suffered bad burns. And again, I think the court held that he was injured in the course of his employment. Now, whilst from a workers' compensation point of view, if you're an employer, you're actually paying the cost of the claim directly. It's being paid by your insurer. These things certainly impact upon premiums that employers need to pay for their workers' compensation. So if you do have employees that are working away from home and that they are induced or they somehow have an activity which can be connected to their work, then you could be found liable and have consequences in terms of workers' comp insurance premium increases.
Thank you, Jeremy. Topic 6. Fatigue. There are some forms of behaviour for which the employer, rather than the worker, may be said to have committed misconduct. Worker fatigue outside of work can be a consequence of misconduct at work. In Stephen and Leanne Ethel Easterman and the Namoy Cotton Cooperative Limited, a cotton gin shift worker was required to work 12-hour shifts with 6 consecutive days on for 2 days off. After a shift ending at 9:30 p.m, she died in a car accident on her way home. The accident occurred outside of her work hours and was not related to her work. The worker was not found to have been under the influence of alcohol or any other drugs. Evidence was presented that the worker was new to working night shifts and had worked for 60 hours on all night shifts in the 5 days preceding the car accident. She had also complained of being tired to her father in the days prior to the car accident. The arbitrator concluded that the worker was fatigued. The employer was ordered to pay nearly $500,000 in workers' compensation to the worker's family. The Commission determined that employment does not have to be the only or even the main cause of the accident, but that it only needs to be a contributing factor. The obvious lesson here is that employers need to take measures to ensure that their workers are not so fatigued from work that they may suffer harm as a result. Although the previous case was about a shift worker, for full-time workers, the Act sets a maximum of 38-hour weeks, but also permits an employer to request a worker perform reasonable additional hours to ensure work is completed. A worker can refuse if the request is unreasonable. Given the dire consequences of pushing workers to the limit, we would caution all employers to ensure their interpretation of reasonable additional hours is consistent with the meaning given by Section 62 sub 3 of the Act. That subsection lists factors to be taken into account, such as whether the additional work will present a risk to health, the worker's family responsibilities, whether the worker receives overtime payments or other compensation, the amount of notice given, etc. Topic 7. Working from home. This is another area where the employer could be said to have committed misconduct. Employers who permit or require their workers to work from home should be aware that health and safety standards apply to all work sites, including a worker's home. In Zybart and Simon Blackwood, a fleet service manager for a logistics company injured his back slipping as he alighted from his shower. At the time, the worker was trying to answer his employer-issued mobile phone. Both parties agreed he was contractually obligated to be on call, and the employer expected him to answer the phone. The call was work-related. While the workers' compensation regulator initially denied his claim, the worker was successful in appealing to the QIRC against the decision after establishing that the injury arose out of or in the course of employment, and that his employment was a significant contributing factor to the injury. Naturally, some employers may form the view that working from home presents too great a risk. This may be appropriate in some limited circumstances, but most workers have a right to request flexible working arrangements, which can only be refused on reasonable business grounds. Employers with the means to do so should conduct an inspection of a home to determine any hazards, and to require the worker to either avoid those hazards or make good the hazards. To further mitigate against risk, employers could institute a policy which requires workers to declare hazards from time to time. In that way, the employer cannot avoid its duty to provide a safe workplace, but it could show to an authority that it took active measures to meet compliance with the duty, notwithstanding an accident occurring. Question time.
David, there were a number of questions that did come through from listeners which I might deal with generally for the benefit of others. Firstly, we did have a question about when we were looking at events involving alcohol and workplace events. One question was, what if an event wasn't employer sanctioned, for example, Friday night drinks, where staff decide to go out on their own accord as friends. From a work health and safety point of view, I think an employer or a PCBU under the work health and safety legislation would be fairly safe, because that would not be their workplace and wouldn't be considered to be in control of that workplace. However, I think in the case examples that you gave, it can certainly be seen that there is some liability that rests on activities that occur between employees from a sexual harassment point of view. And I guess also, if you're talking about workers' compensation, if it is an event that let's say occurs whilst the worker is working away from home, like some of those case examples that we gave, then there still could be a liability for events that occurred if they are required to be in that particular place by their employer. We also had a question, I think, if I could just go back and find it on the screen, in relation to social media. And that was more of a comment about whether or not having a clear policy, a social media policy, would assist an employer. It most certainly would. If you do have a social media policy that makes it a prohibition on making disparaging remarks about the employer or the company or other employees or even clients, you can action or take disciplinary action arising from the breach of that policy. So that would most certainly assist if we had that policy in place. More generally though, code of conduct could assist depending upon the breach. Could you rely upon provisions in a contract of employment? Perhaps, but generally with those sorts of types of provisions, we would not suggest they be put in a contract of employment, but put in a policy document. Okay, and we have one other question, which is, I have a question which states, what happens when employees take regular days off, usually a Monday, due to their activities on the weekend, resulting in them being too tired to come to work on a Monday? I work with people who are in their early 20s and find that their weekend activities can impact on their working days. I think that becomes an absenteeism issue, which can be managed through an absenteeism policy. Most employers that have employees who regularly do not show up on a Monday can take some form of disciplinary action based upon absenteeism. If there are issues associated with fatigue arising out of their conduct, then again that is something that could be taken up on a disciplinary front. Another question we have is permanently rostered additional hours within the rules, e.g. staff have a 38-hour week but attend work 40 hours, which is as rostered and have a paid lunch break. Not sure I quite... Yeah, I might take that one offline because I'm not quite sure what the person is asking. We'll send that one out. Just checking to see if there's any other questions. Question. If the employer puts on a Friday afternoon barbecue and supplies alcohol, is the employer responsible to limit how much each employee drinks? The short answer to that question is yes. You should limit the amount of alcohol that is given to employees, particularly if you know that those employees have to drive home. It is about being responsible. It is about doing everything that's reasonably practicable. From a common law point of view, there's been a number of cases where employees have been injured in motor vehicle accidents on the way home under the influence of alcohol after attending employer-sanctioned barbecue and Friday drinks. So the answer to that is yes, you should limit the number of drinks that are available. you need to do everything that's reasonably practicable to ensure the safety of those employees. We have another question on fatigue. Are there steps that can be taken to minimise the risk of a fatigue claim? E.g., are there a reasonable number of hours or certain aspects to look at before allowing workers to exceed their 7.6 hours per day? It comes down to the type of work that a person is doing. If they are performing physical duties, from a liability point of view, you need to consider what the work is, how far they may have to travel after work. Certainly in drive-in, drive-out scenarios, I know for instance in the mining sector where some employees do 12-hour shifts and drive up to an hour each way to attend, employers have put in a number of steps to assist them in managing fatigue. They have fatigue-based apps that they provide to their employees. They organise a carpool. They give training to employees to identify fatigue in themselves and ways and means around assisting in managing that fatigue. There's another question from Karen. What fines / accountability is there for managers that don't do everything that is reasonably practicable? Well, under the work health and safety legislation, if a person is considered to be an officer of a PCBU, they have an obligation to exercise due diligence to ensure that the PCBU complies with its obligations under the Act. If they do not, then the maximum penalty under the work health and safety legislation is for an individual $600,000 and or 5 years jail. That's if they're considered to be an officer. If they're not an officer but they just owe an obligation as a worker for the safety of others at the workplace, then the maximum penalty is $300,000 for that manager. Another question, oops, sorry, it's just moved. Yeah, they're all flying in. Okay, we've got time for 2 more questions. Here's a question, what happens if an employee is injured on an RDO? Is the employer liable for workers' compensation? The answer is no, because they're not at work. If it's an RDO, then they would be at home. So no liability there from a workers' compensation point of view, unless of course they were performing some work, which they wouldn't be. One more question. For a sponsored event after work where alcohol will be consumed, so you recommend that an employer must be responsible for the safe travel home for all employees from the event. I'm not recommending that you are responsible for the safe travel home. What I'm recommending is that you make employees aware that they and that they find a safe way home. So whether they're carpooling or whether they have organised someone to come and pick them up, and that is sent out to the employees before the event, and then you can at least argue that you have done everything that is reasonably practicable in the circumstances. I'm not suggesting that you have to pay for cab fares home for all employees. I'm saying you have to do everything that's reasonably practicable, and that is to raise with the employees that they have a safe means of getting home if they're going to consume alcohol.
Thanks, Jeremy and David, and hopefully you have now gained some terrific insights on this topic, which is never ending. As you can see here, we have a couple of suggestions for you if you do need to review your contracts and policies, or if you don't actually have these contracts and policies in place. It's a good starting point for you, so please contact Jeremy and David and they can help you. Thanks for participating today. As always, we do welcome your feedback, so if you can spare a few minutes after we sign off, you can complete the feedback form. We'll be in touch later this week with a link to the recording for today's webinar. Good afternoon.
Thanks, Jeremy and David. We've covered a lot of information today, and I'm sure our listeners have gained some valuable insights. If you have identified a gap with your employment contracts or policies, we have included Jeremy and David's email addresses, so feel free to contact them directly if you would like to discuss reviewing any aspects of them. Thank you all for participating today. As always, we welcome your feedback, so if you can spare a few minutes after we sign off, you can complete the feedback form. We'll be in touch later this week with a link to the recording for today's webinar. Thanks again and good afternoon.